Well, thank you so much for joining us this afternoon. I know we are very excited to be here and talk a little bit about trust planning with you. My name is Dan Matarrese with McKonly Asbury. I'm honored to be joined by Mr. David Warren with Bridgeford Trust Company. And some of the things that we plan to go over today, we're going to talk about what trust planning is and why it's important, and just maybe debunk some of the myths that we have about use of trust in planning. Then we'll spend some time talking about some scenarios where we have personally seen trusts used for planning for our clients. And then we'll also talk about some specifics on the formation of trust and certain structural components of trust that we thought are worth mentioning as we go through, again, some of the scenarios that trust can be used or should be used in. So without further ado, let's move on right to our first point, which is, what is trust planning? And Dave, I'll leave that one to you. What is trust planning?
Thanks, Dan, and I'm happy to be here. Trust planning generally is an important topic, I think, in any scenario. And often when people think of trusts, they think of ultra high net worth individuals, and they sometimes wonder, how is that applicable to my life? Because I'm, may not be worth $200 or $300 million.
Speak for yourself, Dave.
Well, thank you, Dan. That's a good point. For me and for the type of work that we've done over the years, it's amazing how applicable trust planning is in many different scenarios, and looking forward to talking about that with you as we go forward. But I mean, the importance of it, or really the relevancy of it, can apply in a couple different scenarios, and it isn't just a tax planning play. And I think that's, in many respects, what people sometimes think of first, is that they're trying to shield taxes or avoid taxes, and that's certainly a component of it. But there's more to it. There are aspects of control. There are aspects or ideas around passing legacy from one generation to the next. And often what has unfortunately been, I think, in some respects misconstrued, is often when people think of trust, they only think of dollars, investable dollars. And they don't think about alternative assets like closely held stock or real estate or artwork or anything of value. I mean, when trusts were created 250 years ago out of Massachusetts, they weren't created just to pass investable assets. In fact, they were more centered around the idea of moving property generally from one generation to the next, not only in a tax-efficient way, but also in a way that can establish control and pass legacy to the next generation. So as we go through the conversation today, I think that hopefully that'll become clear that tax planning or trust planning is very important and relevant, and not just reserved for the wealthiest 1% in the country.
Dave, I think that's a great point. And I know from my perspective, I think it is hard to nail down why trust planning is important, because really the answer is, anytime you're dealing with family dynamics and dealing with the different variables that come along with that, trust generally are one of the better vehicles to essentially help get over those hurdles. And we'll talk about some different scenarios, but they could be medical needs of individuals involved. They could be the mental state of certain individuals that are involved in the planning process. So why, again, why it could be important, or what is trust planning? Really, this is about family dynamics or closely held business dynamics, and the possibilities there are somewhat endless.
Well, Dan, you make a really good point, and I think it's worth spending just another couple seconds on it. It's often said, particularly by some planners who probably may not have as much experience with trust planning, that trusts are dead, or trust planning as a concept is passé. And we would argue that's absolutely not the case, particularly now, more so based on the point that you made about family dynamics. And it's unequivocal. There's still no better way to move assets from one generation to the next, or subsequent generations under dynasty trust situations, than trust planning. They've been vetted. They have been established, as I said, over 250 years ago, and they're still very relevant. And I think by the end of this conversation, that'll be pretty clear.
Well, that's great. And I think, again, to piggyback off of that, just to help whet the appetite of those attending, there's many different applications for this. So let's just keep our minds open to what those different things could be, or where trust could be used in the general wealth planning arena.
Well, Dan, could you talk a little bit about scenarios where you've seen trust used from your perspective as a CPA, and how it's been effective?
Absolutely. I'll paint a picture from more of a high-level perspective of, you have mom and dad who are 50% owners in the closely held family company. They own all the stock between the two of them. And now we're thinking about a way to somewhat facilitate transferring stock to the next generation to minimize estate taxes, to give some asset protection, and a lot of other different objectives that we have. But we also are met with some hurdles here that mom and dad are not ready to give up control. Mom and dad are not sure that the next generation is ready to make the tough decisions for the business. So trusts have been used to facilitate a lot of that transfer. Tax being the biggest driver of it. Me coming as a CPA and a tax guy first, we use estate freeze techniques, meaning we get the value today to be transferred to the next generation rather than all the appreciation that may come over the next 10 to 15 years. But over those next 10 to 15 years, we still give mom and dad the ability to be making decisions for the business. And especially in tough economic times, which we've endured, that resonates with business owners. They want to still be able to see these closely held companies through what they perceive as some rough years ahead. So we've used trust in a lot of examples or a lot of scenarios to accomplish numerous goals with families as far as getting the stock into the next generation in a way that allows them to be successful and preserve the continuity of the business.
Talk about you mentioned the sort of freezing the value. Why do you think that's relevant in today's economic conditions?
I think it's a great point. We're still dealing with, although there's been somewhat of a recovery, we're still dealing with depressed values of businesses, real estate specifically, even portfolios to the extent that we're talking about those. If you can transfer something today in today's value, especially in the estate tax environment where we're at the remainder of 2012, we still have fairly high transfer tax exemption amounts, $5 million, adjusted for inflation, so $5.1 million, we'll say. Now may be the time to think about facilitating that transfer and not paying gift tax and avoiding future estate tax. In today's environment, it's essential that we consider it. It doesn't mean we write checks and give away all of our money today and we disregard our future medical needs for mom and dad or grandma and grandpa. But you have to think about it because in most scenarios, there's ways to facilitate that transfer without giving up even the promise of cash flow for mom and dad. And typically, trusts are the vehicles that are used to accomplish that.
Absolutely. I'll just jump in for a moment. What's interesting about the focus, and you're coming at from a CPA perspective, and my background is law and having practiced law. I think when there are a couple different pieces to the puzzle here. When we're talking about transferring assets and the tax implications, that's vitally important and in many respects what drives the conversation. But there's also the idea of inculcating values and family values. And when you talk about moving closely held stock, for example, that isn't just simply a sort of a black and white transition or a transaction. And there's a lot of dynamics that go on, and particularly family dynamics. And where trust can really have an impact here in that arena is the ability to prepare the next generation to become business owners, or to prepare the subsequent generations to understand business dynamics and business formation and business and running a business. And it's often said, and it's something that I've become pretty passionate about over the years, is a lot of folks spend a lot of time, lawyers and accountants and insurance people, preparing the money for the family and preparing the business for the family, which is to say that it's well positioned from a tax perspective and from a asset protection perspective. But there's not a lot of time spent preparing the family to receive the money or the stock or whatever's in the trust. And that's sort of the touchy-feely aspect of trust planning, as it's been called over the years, that I'm particularly interested in. And I think you put the two approaches together, the tax play and the tax protection together with the ability to train and protect the next generation and inculcate values, which is vitally important, particularly for first-generation business owners. It comes together to be really a perfect vehicle. And along those lines of inculcating values and trying to prepare the next generation and subsequent generations for the money, there are certain tools that have developed, pretty creative tools, particularly in the trust world. And one of them is an incentive trust. And Dan, why don't you talk a little bit about that and how that really works in terms of really helping shape the next generation and subsequent generations?
Well, Dave, we can never be sure that the next generation will use assets or use the funds in the exact way that we see fit. And many times we meet with family members, and that's a large concern, is how do I know Junior's ready for this sum of money? How do I know that my daughter understands the implications of this wealth, or even can manage the real estate that we're leaving to them? Again, it doesn't need to be a huge investable portfolio. And incentive trusts or incentive-based aspects of trust allow us to delay or better time the availability of these assets to when certain milestones are reached for the beneficiaries. These milestones can be educational. It can be graduating from college, achieving a certain GPA. It could be getting married. It could be tied to making as much assets available to them that's an amount equal to their current salary. Essentially, what we're trying to accomplish here is giving the creators of these trusts the ability to have a little bit more assurance that the assets are used in a fashion that more closely meets and satisfies their objectives and what they see should be the legacy that they want to pass along to their family members.
Absolutely, and I think that the key here is to produce productive members of society that are aware of the responsibilities of the wealth that they have. And we're all aware of the horror stories of trust fund babies that have suddenly have no incentive to do anything, and understand that no matter what they do, they're going to be well taken care of, so they do nothing. And it's sad, and it's well documented in some of the wealthiest families in the country over the last 100 years. Where second and third generations have literally not only destroyed themselves, but have destroyed their business, the business and the empire that was built in the first generation. So the incentive trust is a really amazing way to capture the essence and what the family first generation or second generation holds dear to them. And if education is something that is important, then to incentivize the next generation to do that is a great way to do it. And as these have developed over the last 20, 30, 40 years, the statistics on the outcome is pretty staggering in terms of the success that these people go on to have to be productive members of society, to understand that they have a lot of wealth behind them, but that doesn't drive their decisions, and they become again productive members of society. Another way to do that is the idea of creating a charitable trust, right along the same lines, but getting into the concept of taking this wealth or a portion of this wealth and creating a charitable trust. And as Dan will tell you, there's lots of great tax reasons to do that, and the government provides enough incentive for large estates to do something like that. What I like to focus on, though, a little bit different than the tax benefits, is there's a tremendous opportunity to train the next generation and subsequent generations about and around the idea of the responsibilities of this wealth. And there's really no better way, perhaps in addition to an incentive trust, but a charitable trust that makes these individuals understand the power of what a dollar can do to a family or to a cause or to a situation where they've never been able to feel or directly impact. There's a lot written on this. There's several different books that we can certainly cite in the materials, but there's no question that this has a big impact. And I encourage clients often to, if they're really worried about training next generation, get them involved in a charitable trust, make them a co-trustee, give them some responsibility, or in some cases, make them the president of a charitable organization that is ultimately supported by the trust, if for nothing else, just to get them thinking globally.
I think what better legacy could we leave the next generation than having them partner with us in our philanthropic efforts? When you deal with first and second generation business owners, as Dave spoke about, that throughout their career and throughout the struggles and the years that it took them to create this wealth, they were diligent in contributing to causes that they believed in. I think there's no better way to instill and ensure that legacy for next generations than to include a charitable component into this. And of course, again, if we go back to current economic environment that we're in, we certainly have an ample list of charitable organizations that are in need or could use this as part of their ongoing fundraising needs. And a lot of times it's a lot easier than you would think to work with the charitable organizations to put these vehicles into place. They're open to it. They are certainly comfortable with the different things that we would try to accomplish through charitable trusts.
There's an excellent book, Dan, that I know you've read called The Ultimate Gift, written by Jim Stovall, Stovall, that does a great job. It's a fictional account of a $1 billion family that left the ultimate gift to what the first generation business owner perceived the individual to be sort of the brightest star in the family, and it involves the charitable trust. It's a great story. It's a quick read, and I definitely would recommend it to anybody who's interested in this particular topic.
Well, Dave, we've certainly painted the picture of the many benefits that trust planning can afford to families that are thinking about the transfer of wealth, the transfer of a family business, and some of the non-financial aspects that go along with it, charitable giving, instilling legacy. But what about a little bit more of a specialized area of trust, where you may have a family member that has a mental or physical disability, to where you're concerned about those individuals having the assets to provide for themselves in the future?
Absolutely. This is where the financial and, the tax implications are secondary, and it's more of a practical application to directly benefit somebody that has a special needs situation. And it can come in a couple of different ways. It can come with a child that's born with special needs that's taken care of while the parents are alive, but parents have a concern at their death of how is this child going to be cared for, and that's a certain type of special needs trust, distinguishable from a special needs trust that would come out of a lawsuit, for example, where a young child playing football in high school gets hurt and ultimately receives treatment that is a subpar, and a large settlement comes from that, from say a hospital or a physician group, and suddenly there's 10 or 15 or $20 million available to care for this child for the rest of their lives. Well, how do you deal with something like that? And that's a different kind of special needs trust, and it's actually regulated differently under the law. They're called the same thing, but they're treated differently. And the point here is that these trusts exist not so much for a tax play, but just to make sure that this individual is going to be cared for the rest of their lives. And in the second scenario I described, where there's a large settlement, there are important implications in terms of how that money is received by the family, and how that money is received by the individual if that individual is over the age of 18. Because there are public assistance available through Medicare and Medicaid and other things like that you don't want the injured party or the person with special needs to not be able to avail themselves of, because they have this money. And often it's misconstrued, where a large settlement comes through a lawsuit like that for a special needs situation, and the family thinks they won the lottery, and I've seen that happen several times, and these trusts are the only vehicle really to protect these assets for the injured party. And not to suggest the family is sinister, but they often are not used to that kind of dollars, or they're not used to those kinds of funds, and so it's not unusual to see them squander monies in much the same way that second, third, and fourth generation people receiving or winning the lottery, so to speak. So these special needs trusts are very, very practical application for trust planning, and Dan, they're more frequent than you'd believe. Right now we're dealing with a couple of questions in that space.
And it's interesting to point out that, from working with entrepreneurs, most of my career, and business owners, they tend to have this misconception, Dave, that they'll never be gone. Yeah. Which means if it's their child or their grandchild that does have the special needs, a lot of times you will need to help them see that we have to think about the day where they're not here and no longer have that income stream to care for this child. Mm-hmm. And a lot of times families don't want to consider that. The thought is, well, hey, as long as I'm working and earning the income I'm earning, or the business is producing the revenue stream for our family that it is, that we have no concerns for this child because we're a wealthy family. But we need to think about beyond ourselves as the person's caretaker. When we're no longer here, even if it's not a question of government funding, it's who's going to make these decisions for them, who's going to facilitate where they live, how much spending money they have. And again, it's not only for those who have the highest degree of care. It may be to a lesser degree, certain degrees of mental illness that you just need a little bit more oversight for these beneficiaries or for the next generation than you do otherwise. Special needs trusts can cover all of those bases. It's not only the furthest degree of where they can't care for themselves and need the highest degree of medical assistance. It could be more along the lines of a mental condition where they just need a little bit more oversight.
Absolutely. That's a great point. And, and along those lines, we probably would be remiss if we don't talk about asset protection trusts. This is a relatively new animal in the trust world. I would say 15 to 18 years old. And the concept of asset protection for any business owner or any family really is becoming more and more of a concern. And, the old days, 15, 20 years ago, there weren't a lot of domestic asset protection options. When you talk to wealthy business owners or wealthy families, you hear them, they would set up accounts in the Caymans, or they'd set up accounts in the Cook Islands because that was really the tax haven, or more particularly the asset protection piece, which is to say the protection of assets from creditors or lawsuits or former spouses. And so over the years, the trust industry or the trust community in the United States developed an answer to that. And it's an answer that's driven by state law. Dan, as we probably will talk about a little bit later, each state has their own laws. There's no such thing as federal trust law. And so asset protection statutes have been put on the books in a handful of states. And it's Delaware, South Dakota, Nevada, and Alaska. Those are the 4 states that have asset protection, or at least the most compelling asset protection statutes. And they have become very, very popular. They have been tested in the courts. And that's another use of trust planning, in addition to the transfer, in addition to the inculcation of values, that has been taken advantage of and has proven to be a very, very powerful protection tool. Dan, why don't you talk a little bit about your experience there?
Interestingly enough, in central Pennsylvania, when we talk about asset protection, one of the reactions we tend to get is, well, we're not doing anything illegal, or we have nothing to hide. Therefore, we don't need to think about asset protection. And as Dave talked about, in the last 15 to 20 years, asset protection is more of, I would say, just as much of a reaction to an overly litigious society as it is to protecting yourself from actual wrongdoing. Paint a picture from the business side. If we have an operating company that uses aircrafts and generally to bring our executives around, or our salespeople, we will generally put those aircrafts in a different entity, a separate legal structure, so that if anything were to happen, we don't subject the assets of the operating company to the claims of creditors if something were to happen with the aircraft. You don't have to be doing anything wrong, but you should take certain measures from the asset protection side to protect your employees, your family, and your company. Trusts are even more so because we're dealing with your personal assets, not only business assets. We talk about the family that has, either through multiple generations, or if this is even the first generation that has owned the business, the amount of blood, sweat, and tears that has been put into accumulating and building this wealth. Threats come from many different places, and your creditors, whether it be unforeseen medical expenses, whether it be lawsuits, other things. There's so many items that could compromise your ability to preserve this wealth for your family. And embarking on asset protection is not hiding anything. It's fully disclosing what you have and using the correct vehicles, and as Dave pointed out, understanding state law to ensure that your assets are protected so they stay with the hands that they should. So again, to debunk some of the myths about asset protection is, we're not dealing with, offshore accounts to hide money. Or using a South Dakota or Nevada entity to hide something from people. Not at all. We're protecting it so it stays within the hands that it truly belongs in.
Dan, that's a really great point. These asset protection trusts have been around for 15, 20 years. They've been tested in the courts and are generally accepted by some of the most sophisticated planners across the country as not being a sham and not being some sort of a negative way to shield money. And as you heard us talk about, we're not talking about shielding or trying to hide or get away from paying taxes here with these domestic asset protection trusts. We're talking about protecting assets, and that's kind of a different concept. So there's nothing negative about that, and in fact, they're greatly encouraged and supported by case law. So by no means are they considered negative, or should they have a negative connotation. Unlike, again, what you would hear when maybe you talk to somebody at a cocktail party that says they have all their assets in the Cook's Island because they don't want to pay any taxes. Well, that's not at all what we're talking about here. Which is an interesting transition into another use of the asset protection trust, which is gaining more and more popularity, particularly among high-end family law attorneys. Wealthy families are always concerned when their children get married, and they're always worried about what's going to happen in the event that there's a divorce. So we all know what a prenuptial agreement is, and we all know that that seems to be one of the only ways to shield or protect a family's wealth from an outsider, so to speak. My in-laws call me the outsider all the time, so that's how that works, unfortunately. But in the big picture, prenups are complicated. They are emotional. They can spark all kinds of problems when trying to discuss that with your spouse-to-be. And if they're not executed absolutely correctly, they can be pierced pretty easily by a sophisticated estate planning attorney. So in comes the idea of an asset protection trust, which I've seen and have been directly part of the planning process, where they're used either in lieu of or in conjunction with a prenuptial agreement. And the beauty of an asset protection trust is it provides the exact types of protections that Dan already described that's available to the business owner or whomever we've been discussing. But in this instance, these assets that are part of the asset protection trust that is in place before the marriage they're all virtually impenetrable from the spouse in the event that there's a divorce. The nice thing about it is that the existence of the asset protection trust never has to be revealed. Unlike a prenup where all the assets have to be revealed and there has to be full disclosure, prudent estate planning using asset protection never has to be disclosed. And that's a real positive to wealthy families because they prefer not to have to put in a 25-page document just how much money little Johnny will get at some point. So we're seeing that more and more. I'm involved with in some instances, family law attorneys across the state of Pennsylvania who are learning this, who like the concept. And, it's a nice way, I think, to sort of round out this discussion as to how are these trusts used. You heard us talk about the transfer ability, the taxation savings, and the prudent investment planning. We've heard now about asset protection aspects of it, and the special needs piece where you can provide for individuals that have been hurt or have special needs. And a topic, as I've already mentioned, near and dear to my heart, is preparing the next generation for the responsibilities and the challenges of wealth and business ownership. And so, going back to where we began, is trust planning dead? Well, I think as we've gotten to this point in our presentation, absolutely not. And I think the question now becomes, how do you form them? What's the appropriate structure? And that's where we're going to go next.
Absolutely. And I think that, again, the best plan falls apart if we can't execute it, Dave. And a lot of times, and Dave has alluded to this consistently, the legal environment, whether it's outside creditors, whether it's a former spouse, they're the ones who will potentially pierce, if you will, some of the asset protection or some of the transfer planning efforts that you've undertaken as a family. Another example is the courts for tax purposes. Any transfer you do, you will have the IRS scrutinizing it when it comes time to settle an estate and file estate tax returns, especially for high net worth families. So the formation and the structure and the administrative work that goes behind ensuring that these trusts are put in place and they are maintained correctly becomes just as essential and just as an important part as the actual plan does. You need to carry it out. It's not good enough to have the best blueprint. You need some good construction workers putting the building up. So, Dave, if you would, I'm going to ask a couple questions around the formation and structure, and I want you to speak a little bit about this. And we'll start with situs, and meaning more specifically the state in which the trust is organized in. Why do you think that's an important consideration for families?
Dan, I think that is a vitally important question. It's been said in literature and white papers and law review articles even that in 2012 the decision as to where to place your trust, which jurisdiction the trust is going to reside in. It's just another way of saying situs, is as important as the decision to create a trust in the first place. And I believe that. Not all states are created equally. I indicated that earlier, that each state has their own trust laws. And what has happened over the last probably 25 years is certain states have been in a race to become the most favorable trust jurisdiction, or be the choice of, the jurisdiction of choice for trust. And it's not unlike Delaware, who has established itself as this generally of the state of choice for incorporating a business. And it's very transitory in the same way that every state has a different approach. And so there's a lot written on which states are the best. This isn't just David Warren's opinion or Dan Matarrese's opinion. I mean, this is based on surveys, and there are certain criteria that these law review articles look at, and Trust in the States magazines look at, and other industry publications. And they look at things like, do they have an asset protection statute, like we discussed? And as I said earlier, no, all states do not. Pennsylvania does not. How do they tax trusts? 4 states in the country do not tax trusts. And it's the same 4 that we've mentioned already. It's South Dakota, Alaska, Nevada, Delaware. Those 4 states, as I mentioned earlier, also have asset protection statutes. Privacy, aspects around privacy. It might surprise you, Dan, to know that in Pennsylvania there is no privacy provision for trusts. But in states like South Dakota, there's a total seal on any trust that's created under that jurisdiction, which is very important to very wealthy individuals, and actually speaks to the asset protection piece of if you can't find out about it, then how can you go after it? Is kind of the blunt way of saying that. There's something new in the trust world that is something we're very excited about. Is the concept of a directed trust. There's only 6 states in the country that do directed trusts, and that's just another aspect of what is being evaluated. Another evaluation point is whether dynasty trusts can exist, and that's really a fancy way of saying can a trust exist forever and ever and ever? And you would think logically, well, sure, why not? But in fact, when trusts were first created, there was this fun little rule called the rule against perpetuities that I had to memorize in law school, which was the worst part of my whole experience. But essentially what the rule says is that at some point, the trust has to terminate. And the reason why that was put in place was to make sure the federal government was ultimately going to have a chance to collect its taxes. Well, South Dakota in the early 80s was the first state in the country to decide to abolish the rule against perpetuities, creating the concept of a dynasty trust, which again means the trust can live forever, which really means that the federal government is never going to be able to tax those dollars. That grew out of the wealthiest individuals in the country clamoring for this kind of legislation, and South Dakota was the first to respond. So those are the areas that are evaluated, and through that evaluation, states are determined to be either top tier, middle tier, or bottom tier. And again, it's worth repeating: South Dakota, Alaska, Nevada, and Delaware are top tier jurisdictions, and it's important to understand that. Just as, Dan, when you would advise your client about the best way to situate their business from a taxation perspective, when you speak more broadly about where to place your trust, there are very, very important issues around taxation, for example, that are measurable. I mean, if a trust is situs or the jurisdiction is Pennsylvania and not South Dakota, 10 years later, you can determine how much money you paid in taxes that you otherwise wouldn't have paid if you would have put it in South Dakota. And so there's a lot written on this point in the legal journals about, or at what point does it become malpractice if you're not, if the idea of an alternative trust jurisdiction isn't discussed, whether it's from an attorney or an accountant or a financial planner, and so the formation of where to put this thing is so much more important than it was 15, 20 years ago. And I think will continue to be important as each year states, as I've said, are literally in a race to be the best trust jurisdiction. And, Dan, you might be wondering, well, what do I think the best trust jurisdiction is right now? And I would say, really any of the top 4 that I've mentioned are all on par to a certain degree. People can argue that asset protection statutes in South Dakota are more robust than Delaware. But the relevant point for us and for our audience is to be aware of the fact that not all states are created equally. Push their advisors on, why am I in Pennsylvania? Are there advantages to being in another state? And if there are, please tell me, and then tell me where I can go to get that accomplished.
Well, Dave, we've spoken about a lot of the benefits of trust in carrying on families' legacy and in charitable intent, in providing for those with special needs. And a lot of that responsibility falls upon the trustee, the individual who is responsible for carrying out and adhering to the trust document. A lot of times they have responsibilities on investment decisions, on distributions. And generally speaking, there can be two different types of trustees. You can have a corporate or individual trustee. Obviously, a corporate being an entity that acts as trustee, which allows for continuity. It's not tied to one individual. And then, of course, an individual trustee, which is you name a family member or a trusted advisor, as trustee. Can you speak about some examples of when either has been used and has provided some benefits, or in your experience, what your advice would be and what questions you believe individuals should be asking as they're planning for who should be the trustee of these trusts?
Dan, that has become also a very, very important consideration, and there's some debate on this point, and corporate versus individual trustee, and again, to make the distinction, it's an individual. Typically, it's a family member. Sometimes it's an attorney. Although I can tell you that practice has been frowned upon by the Pennsylvania and American bar associations. The conflicts of interest that can arise with an attorney actually serving as a trustee has been challenged a bit. So what we're talking about is an individual, usually a family member or some other trusted family friend, versus a bank. And you traditionally see trust powers residing in banks. And what has happened over the years, and it is somewhat of a sad commentary on the fiduciary and trust world, is particularly wealthier families have become unhappy with some of the service and some of the execution of trust administration that happens at the corporate level, especially the larger banks, and the fees. The fees become an issue. So, in many respects, and many times, you see an attorney recommending an individual trustee, and that carries with it some concern. And again, it's a sad commentary because it doesn't necessarily mean that the individual trustee route is better. It just means that the corporate trustee route has failed over the years, and that's again a sad commentary, because there are some problems with naming an individual trustee, and one is they die, which I don't mean to say that in a pithy way, but they're not going to be around forever, and you know that. And so you have somebody that you want to be around for multi-generational issues. We talk about dynasty trusts. We talk about the reasons why we put these in place, inculcating family values. Well, we know that we'll be lucky to get, best case scenario, maybe 40 or 50 or 60 years out of an individual trustee. That's a problem. The other problem is the level of sophistication. Not to suggest that family members and family friends or other advisors aren't bright or smart, but fiduciary law is a special discipline, just like investment management, just like being a CPA, just like being a lawyer. And to anoint somebody an individual trustee who may or may not have a firm understanding of his responsibilities as a trustee, the liability that's there, or even more importantly, the objectivity to deal with family dynamics. We're talking in many cases, particularly with high net worth individuals, very dynamic family situations, lots of conflict, lots of problems, and to name a family member or a family friend trustee, often that person is going to be put in a very, very uncomfortable situation. Can be influenced by other individuals in the family, and thereby lawsuits have come. It's not unusual to see trustees sued in that capacity just because they don't have the experience or they don't have the objectivity, and I think it's fraught with a lot of problems, and easily avoid by appointing a corporate trustee who never dies. Who has the ability to have an expertise in trust administration, who can handle aspects of trust administration and asset management, and then along with that, helping inculcate the values over generations in a way that an individual trustee just may not be able to do. So there's a lot of debate right now in the industry, and I think it's an unfortunate debate. I think that if looked at side by side, there's really no question that a corporate trustee is the better choice. But by default, individual trustees are being named every day just because generally the legal community, in some instances, just has a negative impression of corporate trustees. And as we talk about, there's a corporate trustee, and then there's a further distinction between a corporate trustee that is independent or that's owned by or part of a bank, and that has an impact on how that's administered. But but that's a distinction in a very important conversation that's happening across the country right now.
And again, we think about where we form our trust and who is the trustee. Those two broad questions lead to many, many further discussions, and the answer to those depend upon, again, the specifics of your situation. But as Dave alluded to, you need to consider very strongly who is best suited to carry out the wishes of the trust document, or the what's spelled out in the trust document. And in order to ensure that your legacy is preserved long term, more times than not, a corporate trustee is the right answer. I can tell you from my planning experience, we've had scenarios where clients have set up to have a bank be the corporate trustee, and everything was set, but after the individual passed away, the bank actually decided they would not be trustee of a testamentary trust that was created as part of the estate, because there was real estate involved. And when there was real estate involved, it's not something that they're necessarily comfortable with taking on or choose to take on now. It doesn't fit their mold. That's not an insult to banks. It's not in their best interest. It's not how they're set up. It's not their bread and butter, if you will. So even if you believe you have the corporate trustee set currently, and it is a bank, I think it's important to potentially reconsider that.
Absolutely, Dan, and the ability and a desire to deal in non-traditional assets, such as real estate in your example, or closely held stock, I can tell you that's probably one of the primary reasons why individual trustees are chosen, because often the larger trustees that are attached to large nationally known and well-known banks, locally and across the country, are not interested in dealing in real estate or non-traditional assets like closely held stock or artwork or whatever. And so that's where the distinction of an independent trustee versus a bank-based trustee is very, very important. Independent trust companies have popped up across the country that are willing to deal with non-traditional assets, and it's very, very important to make that distinction, particularly as you look out into the future. And as Dan said, the last thing you want to have happen is the trustee that has been named by a first-generation business owner recuses himself or fires itself, which they can do under the document, and then you're left, the next generation's left scrambling, and could end up settling with an individual trustee who just really doesn't know what they're doing. And closely held stock and dealing with real estate, that's where you most need a corporate trustee. I mean, there's a real irony here in the industry, and it's something that can be, the fodder for a lot of white papers. But where you most need a corporate trustee, most corporate trustees don't want to be.
Absolutely true.
And so that's where the role of an independent trustee, and there are several around. Bridgeford Trust is an independent trustee. We're willing to take on those kinds of assets, and a lot of others, just a lot of other bank-based trust companies just are not. And again, to Dan's point, where it's not denigrating the banks, they have a different business plan. They're primarily interested in managing dollars and managing liquid assets, and that's a business plan that's fine. But it's leaving a lot of wealthy individuals, a lot of individuals generally, kind of out in the cold, forcing them to choose an individual trustee, which is not always in the best interest, and I would argue is very, very rarely in the best interest of the family to have an individual trustee.
In the interest of time, I think Dave and I are going to stop there with a lot of the content of what we have. And if I could sum up a lot of what we talked about before we go into some Q&A, many of the things we spoke about and the topics that or questions we raise are not always the most pleasant. But I will say that the cost of not considering these things to the wealthy families and the family-owned businesses, the cost of not thinking about these things far outweighs maybe the pain of considering those. And yes, there's a lot of time that will be invested on going down the path of true trust planning and wealth planning and transfer planning. But at the end of the day, I think our goal as advisors, and we would hope that the advisors that you work with are along the same lines, we want to make sure that your objectives as it relates to your wealth and what you've created are carried out for future generations, whether those be charitable, whether they be caring for those in your family that have a special need. The goal of this is to ensure that your money and your wealth does what you intend it to do. And I think some of the ways that we talked about intertwining trust planning will give you greater assurance that that does happen. Well, Dave, before we move into questions from those attendees, any closing thoughts from your perspective?
Dan, I appreciate the opportunity to talk with you today. I am very passionate about this discussion around trust planning and the topics that we talked about today. As I said earlier, as we began, trust planning or trust as a concept is certainly not dead, and I would argue even more essential today in 2012 than it was in 1920 or the 1900s, or the turn of the century. And the topics that we talked about today are issues that are touching families and not just the top 1% or the top 5%. It's issues that are facing all families in some way or another. And I hope, if anything else today, we've hopefully addressed what could have been a misconception that trust planning isn't for me or not something that I can benefit from. So thank you for having me here.
Thank you, gentlemen. And thank you all for joining us for today's webinar on Trust Us, a look into utilizing trust in your wealth planning efforts, brought to you by McKonly and Asbury. We will be sticking around for a while to answer some of your questions that have come in, and please continue to submit them or email us directly with any questions, and we'll be happy to answer them. As a reminder, you will be receiving CP credit for attending this one-hour webinar. CP certifications will be sent out via email within the next week. You will be receiving a follow-up email to this webinar with a link to a short survey about the webinar that we would appreciate your feedback on. We will be posting a recap of today's presentation on our blog at www.macpas.com/MA-news. Look for that post to be up by the end of the day tomorrow. And now I'm going to turn it back over to Dan and Dave to answer a few questions.
Thanks, Reed. One of the questions that came in that I thought was pretty interesting, and I'll pose it to you, Dave, and let you take it. It's a question that says, I have read that South Dakota and a handful of other states have directed trust statutes, something we mentioned briefly. I have a general understanding of what they are, but can you please explain what they are and how they work? Dave, you want to take a crack at that one?
I'd love to. Dan, can you hear me okay? Hello?
Yep, we got you.
Okay, great. Absolutely. The directed trust statute is really a brand new animal, so to speak, in the trust world. It's been around for about 12 or 15 years, and it's really changing the face of fiduciary law and the way trust companies interact with investment managers. And here's the concept generally. It splits apart the functions. Literature talks about unbundling traditional services around asset management or trustee work, and essentially how it works is a trustee, an independent trust company like Bridgeford Trust, can serve in a trustee capacity, but does not have to manage the dollars. So the idea of directing a trust is the client can direct who the trustee uses to manage the investment assets in the trust. And so it's changed the trust industry dramatically, because very wealthy families across the country who are saying, well, I like my trustee, okay, it could be a large bank base like Bank of New York or JP Morgan, but I don't necessarily want them to manage the money. So in comes the concept of directed trust, which is a direct response to the concern that people want to use their own asset managers. And so under the statute, they can do that. And the legal phrase and the big word that's tossed around is bifurcation. And how this works so well, or why it works so well, is because of the idea of being able to split the liability. So the investment manager is only liable for its activity as an investment manager, and the trustee is only liable for its activity as a trustee. So what that essentially means is that neither organization or firm is ultimately to be held responsible for the activities of the other. And trust companies love that. Investment managers particularly like that. And as I've said a few times, it's radically changing the face of fiduciary law. And it's changing how trust companies behave and how trustees can work in conjunction with traditional asset managers. So that's the big picture, the description of it, and it's very exciting.
Well, thank you, Dave. Yeah, there's certainly a lot there, as you talked about, and not many states that allow for such a statute, but certainly something that is important and sets some of the top-tier states apart. One of the questions that also came in as well is, my insurance agent has recommended that I place my insurance policy in a trust. Is this a good strategy? A simple one, but I'll go ahead and say yes. Generally speaking, we use what we call ILITs, or irrevocable life insurance trusts, to be the owner of life insurance policies. Therefore, it does remove the policy out of the owner's estate for estate tax purposes. It's a common planning strategy. I would say 99% of the time it's the right move. And the fact that your insurance agent has recommended that is right on par with what we would normally expect. There are some administrative issues that need to be considered when moving policies into an ILIT. You need to make sure you have something you call a crummy letter, which means you need to have a letter written by the trustee essentially each year, which gives the beneficiaries of the trust access to the funds that are used to pay premiums, but those beneficiaries give the okay for the trustee to pay premiums on the insurance policy, and that allows the trust to get the maximum amount of benefit from gift tax exclusions, and as well as the benefit that the trust will allow for estate tax exclusions. Dave, one other question that has come in relative to the conversation of situs is it hard to move trusts from one state to another after they are created? For example, if I have a PA trust but want to move it to another trust or jurisdiction, is this difficult? Dave, would you go ahead and share your thoughts on that?
Certainly. In particularly Pennsylvania, and each state has different laws around this and different provisions and rules. But in Pennsylvania, it's very easy to do. It's just a matter of getting the beneficiaries all to agree and sign off on it. And so in a scenario where somebody has a Pennsylvania trust and for various reasons they would like to transfer jurisdictions to South Dakota, it's simply a matter of getting all the beneficiaries together. It's signed. Everybody has to sign off on a document, and then the document itself is modified to simply change jurisdiction. It does not have to go to court. It does not have to be an expensive process at all, and it can happen very, very quickly. And in fact, that's what we're seeing happening a lot. Most states have a similar provision because the idea is they want to. Courts want to make this easy for clients who want to move trusts from one state to the other. And we find, and we're working on a situation right now where we have multiple trusts, 10 or 15 different trusts. It's just a simple, it's an issue of wanting to create a better trust jurisdiction or put them in a better trust jurisdiction, rather. And that's what we're doing, and it's a relatively quick process.
Thank you, Dave. Yeah, that certainly makes sense from our perspective. The flexibility to be able to change that is certainly valuable, especially as states do evolve and change over time and present new opportunities for our clients. Well, we have time for one more question, which I'll go ahead and ask, and it came in from one of our attendees. And the question is there any benefit to having a grandchild as beneficiary of a trust versus your child? Great question. I'll share my thoughts first. I'll also pose it to Dave. There's something called the generation skipping transfer tax, another level of gift tax or estate tax, if you will, that comes into play when you are skipping generations, meaning if you're giving assets to your grandchildren as opposed to your children, you potentially have another layer of tax to consider. So one of the disadvantages of giving directly to grandchildren when you're skipping a generation is you may have more tax implications. But just like the gift tax exemption and the estate tax exemption, we also have a generation skipping tax exemption that would allow us to get over that hurdle. Some of the other potential disadvantages to giving to grandchildren is you usually have minors, which I mean, particularly not of age to manage assets. So trust planning becomes especially essential with those individuals. We spoke about dynasty trusts earlier, and they are typically used to facilitate such a transfer. And even if it's not a dynasty trust, it's called a GST trust, or a generation skipping trust. It's a trust specifically set up for a generation beyond your children, so your grandchildren and beyond. One of the good ways, or one of the benefits of doing so, is you do escape some potential asset protection issues that come into play if you leave money directly to your children. So let's say an example where your children are beneficiaries of a trust that you create, and at a certain age, assets are made available to them to own outright beyond the trust. At that point, anything that your child does, whether it's things that may cause potential lawsuits or a potential divorce, whatever it may be, that subjects those assets to the claims and the risks of the creditors of your children, and thereby they could not make their way to your grandchildren, meaning the assets could be exhausted or spent before your grandchildren get a chance to benefit from them. So there is a benefit in saying, I'm going to remove that risk and set aside money in a trust specifically with my grandchildren as beneficiaries, and I remove that variable of what happens if these assets become available to my child. So there are certainly some benefits. Dave, anything you can think of on that topic?
No, Dan, I like what you said and agree with everything. As you talked about, though, earlier in our presentation, the part that I'm particularly excited about is the ability to inculcate the family values into subsequent generations, and sort of the touchy-feely aspect of preparing the next and subsequent generations for the responsibility of wealth. And these generation skipping trusts do that very, very well for grandchildren. And in many respects, we work with folks who really like the idea of being able to control assets to the third generation, I guess, and they can write the trust in a way that really controls how the money is going to be dispersed. They can do it in the form of an incentive trust, as we talked about. They can do it in the form of a charitable trust. And so in addition to all the tax benefits, which of course drives a lot of these decisions, it provides a great opportunity for first generation to have a direct impact and to inculcate their values directly to the third generation. And it's worked very, very well, and we've worked with families specifically around those issues, and that he was even more important to them than the tax benefits. So as I said, I agree with everything you said, Dan. Just wanted to mention the aspects of family planning and wealth planning that could be very beneficial as well.
All right, thanks again to everybody for joining us, and we're going to be signing off now. So I just hope everybody has a great afternoon and has a great weekend coming up. Thanks again.